Hi there, it's Catherine Cavella from IP Works Law. I'm just wanted to do a video on a topic that comes up a lot, um, and that is why authorship doesn't matter when it comes to trademarks. So this is a really tough one for a lot of content creators and like brand professionals in particular, because as creatives, we are um, used to the idea that when we create something, we have authorship and ownership that gives us the right to control the use of that thing. And it gives us the right to get paid when we sell or license that thing to someone else. And so that's a very natural, um, you know, concept. And that applies with patents and copyrights, which are both areas of intellectual property law where the law is based on the idea of property, which is the idea of rewarding a creator or an inventor for creating something of value for the world. Um, and, in the case of copyrights, it's creating something of cultural value. That's really what it's about. That's where it's grounded. And in the case of patents, it's really directed at creating, rewarding inventors for creating something that is of technological value, an innovation that helps in industry in some way, or just helps people in their daily lives. It doesn't have to be industrial. It can be something that just helps, people like a particular design of a clothing hanger or something. It doesn't have to be an industrial thing. But the point being that in both copyrights and trademarks, copyrights and patents, the law is coming from the position of rewarding someone who created something of value and put it out into the world. I will also point out that what goes with that is that the rights that the creator gets, the patent rights, the copyright, are limited in time. They don't last forever because the balance is you create something of value, you put it out into the world, you get to enjoy the benefit of that for a limited time. In the case of copyright, it's the life of the author plus 70 years. In the case of patents, it's roughly 20 years. Um, and after that, in both cases, the thing that you created is public domain. It is there for the rest of eternity for everyone to use for free. So that's the trade-off. You get to enjoy the monopoly for a certain limited period, and then everyone else gets to enjoy it for free after that. Trademarks are completely different, and that's because they're not grounded in property law. They are intellectual property. Just like patents and copyrights, trademarks are also intellectual property, and so are trade secrets, by the way. Um, but with trademarks, the law is not based on property law. It's not based on this idea of rewarding a creator either. It's based on consumer protection. It comes from the idea that when someone adopts, when we put goods or services out into the world under a brand, we are helping customers recognize um, the origin of the goods and services. That's really what it's about. And it comes back from, I believe the origin of it was sword makers, obviously many years ago when people had swords, where you needed to, you're trusting your life to this sword. And the um, blacksmiths making swords, they would put their mark on the blade so that the person using the sword can be assured, I trust that this is a sturdy and good blade because I know the sword maker and this sword maker does really good work. So I will trust my life to this blade. And you can imagine if someone puts that mark on an inferior sword, that's going to have consequences. That's going to be bad. This is the origin of trademark law. It's about protecting the consumer. It's not about rewarding the creator. Right? The creator is rewarded, the creator, so to speak, the sword maker is rewarded by being successful in business because everyone wants those swords because they are the best or whatever whatever the brand stands for. And so really trademarks are all around branding, and branding is all around the expectations and the relationship between the provider of the goods and service and the customers. So this is a fundamental difference. And what that means is that the person that creates the brand, like the person, if you hire a company or a person to like come up with the brand name for you, they're the ones that create, so-called created this brand. They're the ones that figured out this amazing, I am not knocking that. That is a very difficult, I am terrible at coming up with brand names for things. I'm good at protecting brand names, but I'm terrible at coming up with good brand names. But there are lots of branding professionals out there that are fantastic at it. And by the way, I will happily make recommendations if you're looking for such a person. I know some really great ones. But the point is that those branding professionals that you hire to create, to come up with your brands, they don't own the words that they create. And so this is why they want to make sure that they're paid before they'll turn over the collateral and all these things. And if you're a branding professional, you need a master service agreement to make sure that you actually can control your content so that you can get paid. Because what happens, and I have this conversation at least once or twice every couple months, I'd say twice a quarter, where someone created, came up with a great brand for someone, for a company, and then they let the company use it, and the company starts using it, and then the company refuses to pay them. Maybe the company promised something to them and then fell back on the promise. Um, Promises like that need to be in writing so that you have something, and they need to be signed, by the way. But the point is that when they then, I will often hear from these people who say, like, this company stole my work, which it's a true statement. Like in the scenario I just described, that is a true statement. The company comes to a branding professional and says, come up with a brand for us. Branding professional does that, and then the company takes it and runs and starts using it. Yes, they did wrong. They did wrong, the branding professional, that is wrong. And it's hopefully, I mean, it is a breach of contract. Whether it's a provable breach of contract depends on whether you have a signed contract that you can present as evidence. But it's definitely a wrong. I'm not suggesting it's not. The difficulty is that those branding professionals will sometimes come to me and say, I sue them for trademark infringement because it's my brand. And I have to say, it isn't your brand. You made it up, but you're not the one using it, and you never were the one using it. They're the ones using it. So unfortunately, under trademark law, it's their brand. And so this is hopefully useful for both those of you, who are using trademarks that someone else created. But also, I hope it's helpful for branding professionals. The only way you can protect yourself from that situation is to have a signed contract in writing, to make sure that if a company does start using a brand that you created for them and they didn't pay you under the contract, that you actually have a signed contract that you can then sue them for contract, for breach of contract, because you will not be able to sue them for trademark infringement. You do not own the trademark, even though you are, in your mind, the author of the trademark. The authorship is irrelevant. They can stand up in court and say, Judge, yes, this person did create this, they came up with this brand and we love this brand. And so we've been using it continuously for 5 years, and no, we did not pay them. And it's not trademark infringement. The trademark law doesn't care at all who made up the brand. In fact, you can revive an old brand if there's an old brand that you love that has, the company is gone and they're not doing it anymore. And it's been, say, 10 years since anyone did business under that brand. You can start doing business under that brand, and you can register a trademark in that brand, even though you're not them. This happens all the time. So anyway, I wanted to do this video just to sort of answer this question. It's a very common one, and to make sure that you all understand that with trademarks, who made up the word or who came up with the logo really doesn't matter. With a logo, there might, again, it's copyright might come into play, because with copyrights, when you draw something, when you create it, you are the owner, the author and owner of the copyright, unless there's been a transfer. And so with a logo, you might actually have a copyright infringement case. You will not have a trademark infringement case in either case, whether it's a logo or a word. And in all cases, if you are a creative professional doing work for others, make sure you have a clear and complete master service agreement and scope of work, something to define the work you're doing for the company and the terms and what rights they have before they pay you in full. Make sure that you have that all in writing so that at least you can have in writing that they are not permitted to use the trademark until they pay you in full. Anyway, I hope that's helpful. Take care. Bye.